So, like I was introduced, I am an intellectual property lawyer, and today I'm going to be speaking on the future of intellectual property ownership specifically. And in the course of this particular webinar, I'm going to be explaining the importance of intellectual property ownership and how and if we can actually do without it. So, intellectual property plays a very vital role in everyday life, which is which should be obvious, but unfortunately isn't, because a lot of us do not think of intellectual property as property. And what I mean is, a lot of us do not think of intellectual property as something that we can own, something that we can sell, and something we can pass on to our kids after we are deceased. But I believe that with time, we're going to understand the nature of these things, and then we'll see the role it is already playing. Because whether or not you understand it, it's already an active, it's an actor in your daily life. And however, to be able to get to understand this, then the first thing we actually need to do is to know the difference between an idea, an intellectual property rights, and intellectual property laws. So in whenever you go to any workshop about intellectual property, you're going to hear all these phrases being thrown around, and it's easy to just mix them all up together, thinking that the intellectual property itself is the same as the rights and is same as the laws, and an idea is also an intellectual property, which is not. In this course, you will understand how to manage intellectual, or rather, in this conversation, rather, you understand how to manage intellectual properties at different stages of their life cycle, and we'll explore the untapped potential in why ownership is no longer important. Now, that kind of sounds contradictory because we're trying to explore intellectual property, but unlike other kinds of properties like real estate, securities, and chattel, that's like basically movable properties. Intellectual property, you do not need to own it to be able to enjoy it or basically get fed by it. And with that, I will start with the concept of an idea. What is an idea? Ideas are thoughts, concepts, suggestions, or plans that are not yet fully formed or expressed. So that's like the most important part of describing an idea, the fact that it has not yet been expressed. So that is the fundamental difference between an intellectual property and an idea. So the fact that you have an idea about something in your head does not mean that you own it. It's just that an idea. Then the next thing is intellectual property itself. So intellectual property is the expression of the mind. So that is how it differs from an idea itself. So an idea basically is just the thoughts, is the plans, is the concept, but it is not yet fully formed. Now, when the idea becomes fully formed, that is when you can describe it as an intellectual property. And when I say fully formed, I don't mean that you have the complete plans in your mind. I mean that you have executed. So I guess the best way to describe an intellectual property is when you have a prototype. So you need a prototype to be able to have ownership on your idea. So the moment is still in your head, because the thing is, the principle behind this under the law is that many people can have the exact same idea. The only way the law can determine who owns it is who executes first, who expresses it first. So execution is key. Now, intellectual property is the expression of the creation of the mind that may be perceived by sight, sound, smell. And when I say it may be perceived, does not mean that it has to be. So there are some intellectual properties that you may not be able to see. A good example is something we call geographical indication. This is when you own, or rather, when a group of people can claim ownership to a particular intellectual property because it originated from them. You get. But we'll move on to that later on in this presentation. So other intellectual properties that you're going to be used to are usually perceived by sight. So we're talking about artwork, things that you can see. Then by sound, audio. And audio doesn't necessarily have to be music or even like a stand-up comedian. It can also be a news broadcast. That can also be regarded as intellectual property. Another good example would be a church sermon. As long as you can hear it, it's intellectual property. Another good example is something that you can smell. So we're talking perfumes. Um, many people that's why you see that a lot of people hide the formulas for how they create their perfumes, because that formula, that unique smell, is actually their intellectual property. Now, not every country recognizes smell, and when I say recognize, I mean not every country protects it. So it may recognize that you own it, but not many countries have the laws to protect the intellectual property governing smell. Then we have things like designs. So designs are something that you can see. We have music, something you can hear, video, something you can also see, and other kinds of products that you can think about. Another good example would be maybe even your phone. Your phone is an intellectual property, or rather has many intellectual properties in it, because I mean the design of the phone itself is also intellectual property. Now, the difference between intellectual property and intellectual property laws is simply in the word law. So your intellectual property is your photograph, but the law governing the photograph is copyright. So copyright is not your intellectual property. Copyright is just the name of the law that protects your intellectual property. So when you think of your intellectual properties, I want you to think about your films. I want you to think about your designs. I want you to think about your music, your photos, your artwork. Those are intellectual properties. So it's very important to get the terminology correctly. Then intellectual property laws are the legal systems that actually control these creations that you have. So in the course of this presentation, I'm going to be saying IP. IP meaning intellectual property. So common IPs, we have brand identity. Your brand identity is your intellectual property, and good examples of them are your logos, your brand names, and even your collection names. So collections, for instance, if you own a fashion brand and you release a collection, let's say you call it the Hamatan collection, you can actually go and register the word Hamatan if you're lucky and the name gets accepted at the registry as the name of your collection. That way nobody else can actually replace, or rather replicate the exact same thing and call their collection the Hamatan collection, right? So your brand names as well. Basically, a good example of somebody that used her actual legal name and registered it as a brand name would be Omotola. So no other person can use the name Omotola on its own as a brand name in her industry. Now, if she had registered it in many classes, then maybe many classes being basically many industries, then maybe those other industries as well, you won't be able to use it. But for now, just her industry. Then another good example of an IP is your design. So we're thinking about your architectural sketches, your fashion sketches, your designs, your patterns, your prints. Then we have marketing content, we have videos, music, marketing copy. Basically, for instance, this famous adverts in Nigeria, maybe it's something like "Mama, you do well," or things like that. Those copies, those lyrics of those songs, those are also intellectual property. Photographs, literature, basically whether it's a poem, whether it's a novel, whether it's a drama, your film, music, art, even your business secrets. So for instance, let's say the formula for creating Coca-Cola, the fact that it's a secret, yes, that's secret. Or it doesn't even have to be just your um not it doesn't necessarily have to be the ingredients list. It can also be things like your business plan. That's also intellectual property. You notice that a lot of business plans templates actually have a non-disclosure clause within it, saying that nobody's allowed to replicate or use the information they get there for personal purposes within a particular period of time. So your business plans are also your intellectual property. Your vendor and customer lists, yes, those things are very important, because if your business rivals or other people, your colleagues, get a hold of those things, they can actually use it against you, or your business can somehow suffer loss as a result of that. So your financial records as well, your standard operating procedures, how you run your business that is unique and that is very effective, your work products. Even for instance, let's say as a lawyer myself, if I prepare a contract, that is my work product, right? So even if the contract itself, it's not intellectual property that I can register, or better yet, even if it's not something I can make money from, it is actually my intellectual property, and anybody that copies it word for word, I can actually sue. That belongs to me because it's my work product. Then we have mechanical innovations, machines, um factory made machines or just basic machinery. We also have geographical indications, like I mentioned earlier in the presentation. Those are unique cultural elements. Now that brings us to intellectual property laws. All the intellectual properties that we mentioned earlier are actually governed by very specific laws. So your brand identity is governed by trademark. Basically, your logos, your brand name, collection names, those things, anything that involves identity is governed by trademark. Then anything that involves design is governed by industrial design. Now, there's a very thin line between artwork and industrial design. So if you make an artwork for it to be replicated or mass produced, maybe as t-shirts or any form at all, then that becomes a design and it's no longer a copyright. It's a very tricky law, but that's basically where the line is drawn. Then for designs as well, like I already mentioned, architectural designs, fashion designs, they're all protected by the industrial design law. And the industrial design law in Nigeria is actually called Patent and Design Act. It has other names depending on the country that you're registering it in. In Nigeria, the trademark law is called the Trademark Act. Then we have the Copyright Act as well. Copyright is basically what protects any kind of content. So I'm talking about content that you can hear, content that you can watch. So we're talking videos, audios, things that you can read, artwork that you can enjoy. Those things are protected by copyright. Then we have business secrets. Those are protected by NDAs in some countries. So NDAs are basically contracts, and that is how you can protect your business secrets, like I mentioned, your SOPs, your customer lists, and the rest. But there are some countries around the world that actually provide for registration of your business secrets. So you can go and say, okay, these are my trade secrets. I'll submit to the government. The government will give me a certificate. I'll make some payments, file some papers, and then anybody that uses those things in those documents, or better yet, anybody that reveals the things in those documents, whether it's my employee, whether it's even my friend, or even a spouse, whoever breaks it, whoever releases the information out to public, because remember the keyword is secret, right? You can now sue the person, and then how do you prove that you own that particular business secret? It's by your registration. But in Nigeria and many other countries, there's no form of registration for business secrets. And part of the reason is because it's argued that multiple people can have the exact same business secrets. What matters is how well you keep it. So the responsibility is on you to be able to keep your secret. And it's also your responsibility to be able to create airtight contracts with everybody that you interact with, because you can reveal your business secrets by yourself. And those contracts, of course, always have conditions in which you can actually sue people. You can't just sue people helter-skelter because somebody knows something that they shouldn't, right? Then the next is patents. Patent law protects mechanical innovations, and we're also talking about inventions as well. So then we have geographical indications. I kind of like geographical indications, but I'm not going to go into it in detail. I'll just give you an example so that you can have an idea of what it is. So it's like a sign, a name, a symbol linking a product's unique traits rather, to its place of origin. So a perfect example, my favorite example ever, is the Ghanaian kente. So this year it was registered as a geographical indication, meaning that anybody that uses it has to credit Ghana. Anybody that wants to use it in their collection, maybe on the runway, any country that wants to display it in any way has to mention the fact that this originates from Ghana. And last year, they were able to get the kente into the UNESCO Intangible Cultural Heritage List very successfully. And I'm hoping that I'm going to hear about many more countries doing the same with a lot of culturally relevant intellectual properties that we have. Now, the next thing is intellectual property rights. So the first thing we talked about was an idea. The next were the IPs, then the IP laws, and now we're talking about the IP rights. So the laws govern how the IPs itself are created, who owns them, and basically puts a fence around them, who is allowed to use them, who is not allowed to use them, and things like that. Then the rights basically are the list of things that the law provides. So some of the rights that you have rights to reproduce your work, distribute them, modify them. Now, the thing about intellectual property rights is that it doesn't necessarily mean that you are the um it doesn't necessarily mean that no other person can see it or use it or anything. It just simply means that you have monopoly over it. So you're the one that will determine who can use it. So it's a sense of control. It's giving you monopoly over this thing that you've created. However, there's an exception. So in as much as you have monopoly to use this thing, your monopoly is limited by time. So I'll give an example. A lot of copyrights like sound recordings, like broadcast and the rest, after 50 years, anybody can use it without permission. They can use it without giving you credit, and they can use it without paying any license fee. Um, Basically, that's one way to lose the monopoly when the monopoly period ends. Another way to lose monopoly is if you give it up by yourself. So if you waive it, then it goes to the public. Anybody can use it. However, there are limits to which you can, or let me not say limits, but there are different ways you can waive that monopoly right on intellectual property. So you can actually have like a copyleft agreement stating to the world that, okay, people can use this, but to this degree. And I think a better word instead of copyleft for better understanding would be open source rather. Yes. So people in the tech world understand that if something is open source, it means that anybody can use it. So that's basically what happens if you give up your monopoly rights to intellectual property, because most times than not, many people can be able to access your intellectual property. So for instance, if it's a picture you upload on the internet, many people can just download it, right? However, they cannot use it commercially. That is where the monopoly comes in. So they may be able to repost, because like I said, there are limits on this monopoly that you have, apart from limits to time that you use it and you giving up the monopoly. People can actually use it for educational purposes. They can actually use it, they can just post it and give you credits without asking your permission, depending on the nature of what it is. But when it comes to commercial use, or they can also critique it as well. They can um post news about it, but they cannot use it for commercial reasons. They cannot earn money from it without getting your permission first. And so that's about it. That's the difference between the idea, the IP itself, the laws, and finally the rights that you have, that those laws give to you. The next thing will now be the lifespan of these laws. I would like you to have an idea of how long it can be. So I mentioned earlier that copyright gives like 50 years for some things, and then there are some kinds of contents that you have monopoly for the entire lifespan of the person that created it, plus 70 years after that person dies. So I'll give a good example. Someone like Fela, for his entire lifetime, all his songs belong to him. Or he had monopoly on all his copyright on the lyrics itself, because for sound recording, as the audio recording of songs, is just 50 years, even though that was not the law before. But right now it's 50 years. But for his lyrics, it's for his entire life, plus 70 years after his death. So we're talking about monopoly that still runs even up to your grandchildren and maybe even your great grandchildren. They can still enjoy the monopoly, and people would still have to pay it before they can use your work commercially. Then for brand identity, that's the only kind of IP that can last forever. But it requires that you renew it regularly, religiously, make sure you don't make any mistake. It also requires that you actually use it. So, for instance, if you register a trademark and you don't use that trademark for business dealings, it's not on your letterhead, or your company has not been active for more than 5 years straight, you're going to lose your rights to that trademark very easily. It can just get revoked from the trademark registry. And a couple of other things as well, but those are that's like the most important thing. You have to use your trademark and you have to renew it on time. Now in Nigeria, you own trademark for 14 years, and then after every 7 years after the initial 14 years, you have to keep renewing the trademark. And there are many brands that we can think of around the world that still own their trademarks, right, that are like more than 100 years old. The reason is because they keep renewing and renewing and renewing. And it's very easy to think that, oh, trademarks are not important. But when you think about the fact that brands like Disney own more than 200 trademarks, then you can have like a double take and realize that these things are actually important. Then the next is design. The legal protection for design can last as long as 15 years. And in Nigeria, we call them industrial designs, but in the US, they are called design patents. In Nigeria, patents are different from designs. Patents are only for technological innovations and inventions, but abroad, a design patent is basically an industrial design. Then we have so basically just know that depending on the country in which you're registering, you may hear it bits um different terminologies. Then we have business secrets. They only last as long as they're secret. Then for patents, it's about 10 to 20 years, depending on the type of patent. So utility patents, 10 years, regular patents, 20 years. So what happens at the end of the lifespan? I already gave an inkling to it earlier when I said that at the end of your at the end of the lifespan of your intellectual property, it's now free for the public to use. That's actually something called the public domain. So what happens is it leaves monopoly and enters the public domain. And in the public domain, everything is free. You don't need permission, you don't need payment, and to be honest, you don't necessarily need to give credit. However, it's ethically correct for you to give credit. You have to give credit where credit is due, but technically that's very hard to enforce. So intellectual properties live forever, but your rights do not. That is one of the reasons why I had to actually differentiate between the right to the intellectual property, the laws to the intellectual property, and the intellectual properties themselves. So your song will live forever, but that monopoly you have to the song does not live forever. And except for brand identities, if you have a good succession plan, or rather, except for brand identities, that if you have a good succession plan, that they will maintain religious renewals. That's another reason why when I say succession plans, I don't just mean having a next of kin. I'm talking about your business. If today you collapse and you cannot continue working, do you have anybody that can fill in your position for you? Do you have anybody that will take all your intellectual properties seriously? Or are the people that work for you the kind of people that will just sell your business easily? Or maybe if they enter into the seat of the CEO, will they just sell all the intellectual properties and focus only on the real estate assets? So you have to think about all these things to be able to maintain things like this. Then the next is that when the lifetime of your rights end, your work will enter the public domain. It's free for all. You can actually also give up the monopoly, like I mentioned earlier, through copyleft and open source. And a good example is when NASA, that's the space program in America, in 2016, that's about 9 years ago, they released 56 patents to the public domain. Now, it's very easy to think, okay, now I understand intellectual property, I must own, I must get, I must protect. But the issue right now is that we're not really in an innovative, or better, we're not in an inventive era anymore. Almost everything that needed to be discovered has already been discovered. Almost every technology that needed to be created already exists. And many times, what we actually need to do, instead of stealing from others, we can just simply go online. Oh, I need this particular technology. Go and check. Is it in the public domain? And how do you know if it's in public domain? Find out the registration date. When was this thing registered? You can go to your local patent or intellectual property registry. You can also go online. Personally, on my website, lawyercafe.org, I published a document January this year that highlights, I think, more than 100 different songs that have entered into the public domain. So people can actually sample those songs for free. You don't need to look for somebody that's, you don't need to, especially if you can't afford to pay licensing fees. You don't necessarily need to just collect any random song you see on the internet. No, go and find out the things that are in public domain. Use them to create, because almost everything that needs to be created that is 100% original already exists. There's nothing new under the sun. Not entirely. Most of the things that we're going to be doing in our era is actually building on the things that people before us have already built. So like I think Sir Isaac Newton said, we have to stand on the shoulders of giants. Instead of dragging for originality and saying you stole this, you stole that, you might as well just use what already exists, something that is already in the public domain, and create something new. A good example now in terms of the film and entertainment side would be the Winnie the Pooh story. It has entered the public domain. Anybody can make a derivative of that story without getting into trouble. But if you decide that no, I want to use Frozen and a different cartoon that belongs to Disney right now, that's still under copyright protection, you can get sued. And then you're like, it's not fair, is this, is that. But how about doing your research, find out actually what exists? And for an organization like NISA to release 56 patents to the public domain, it means that there are many innovations, there are many inventions that are actually free to use now. So if you are in tech, if you are an inventor, or if you are somebody that works in that field, it's very important. Go and check. These things exist. You may find out that there are a lot of things that you thought you couldn't touch because they were owned by foreigners or they were owned by big organizations are actually free right now. You may not have to pay a lot, especially if your business is still very young. So basically, the future of intellectual property is licensing, open source, and the public domain. In as much as there's a lot we need to learn about intellectual property, I believe that right now where we are, we have to tell ourselves the truth. We have to tell ourselves that, okay, the chances that what I'm going to create is 100% original are low. And the last thing I need to do is to have a cease and desist letter in my email, or to have a court order, or to wake up one morning and everything I've created has been taken off the internet and I've lost all my customers, I've lost all my hard work. It's better for you to go to the public domain. Of course, you can always license it, reach out to people, ask for permission. But how about just going to the public domain? Now, licensing is basically getting people to give you permission to use their work. Open source is when the monopoly in your intellectual property expires, and then public domain is when you no longer own the intellectual property. So in as much as your intellectual property can your monopoly, the monopoly in your IP can actually expire, I want you to know that the monopoly in other people's IPs around the world have already expired. Many people's IPs have expired. Go and look for them. Of course, on my part, I'm also going to publish more materials about more intellectual properties, especially in the tech space, about patents that would expose you to many things that you can actually use for free. Now, this will bring me to the stages of intellectual property management. Because of time, I'll kind of run through this. The first stage of intellectual property management, of course, is creating. This is when you create the prototype and everything. So that's when you turn the idea you have into something fixed, something transferable. And the next step will be the protection. This is where you have to register. The next step is IP valuation. This is very important when you're seeking funding or you want to give out shares in your company or your business. But you can always skip the creation and the protection part and then just go straight to valuation and getting funding by doing what? By going to the public domain. Now, the public domain is not a place. You actually have to do your research, and or a good shortcut would just be get an intellectual property lawyer. They can find out the things that are in public domain, give you a list in the particular field you're looking for, and you're good to go. Then the next is IP sales and acquisition. So remember I said that one thing we have to remember is the fact that IP is a property. In as much as many people don't yet recognize it, it is a property, and it's a bit better than other properties because unlike real estate, you can move it from place to place. Unlike physical products like maybe this mouse, you don't need to courier it anywhere. You can always send it on your laptop. You can always send it online. That's the beautiful thing about intellectual property. It doesn't necessarily have to, it doesn't have the trappings or the limitations that other kinds of properties have. So when it comes to sales and acquisition, it is beautiful. It's a lot easier than real estate and other kinds of properties. And then the last stage is the enforcement of the rights. This is of your IP rights. This is not the last stage technically, but second to last stage. This is the stage where you find yourself in litigation, going to court, and yes, doing other things, working with the police, EFCC, and customs. And then the last point is competing in the public domain. And this is not necessarily for you looking for things in the public domain, but for you who your intellectual property has entered the public domain. So for instance, if you had an invention when you were really young, and let's say you were 10, or let's say even as young as 20, right? Well, 20 is older than 10, but let's say at the age of 20, and what's it called? You have a new product, you patented it, and then you were not able to do a lot of things with it because you went to school and many things happened, you got a job, and when you finally had money to create to create like multiple versions of that particular product, make money out of it, you only had 2 years left. So let's say you were 20 when you registered it and now you're 38 years old. You only have 2 years left for you to be able to use that. What do you do? So this is where competing in the public branding is important. This is where IP valuation is important. This is where collaboration and working with people is important, so that when your product enters the public domain and other people are free to use it, you will still be able to stand out and people will trust you more. And so with that, I'll come to my conclusion. Intellectual property is a form of property, but it has very unique rules. Like I mentioned before, it is more attractive for investments because of the ease of transfer, unlike real estate and even chattel that needs physical border control. Ownership is not the most important thing in intellectual property. A license or a public domain access can also be solid foundations to a profitable business and a beautiful world. And I want you to remember that the system is a constant balance between rewarding creators and ensuring public access to ideas. So it's not more important for you to have a monopoly. The system wants the whole world to be able to use that. So you shouldn't, the fact that you invented electricity doesn't mean you are the only one that should make money from your electricity. Your time will be running out. You will have monopoly, but for only a period of time. And so, with that in mind, I want you to know that money follows excellent execution, not necessarily originality. It's how you execute. So, for instance, if you're the first person to have an idea about something and you never express it, you don't own it, and somebody else expresses it, then that person owns it. That's number one. Number two, if it enters into the public domain, your ownership doesn't matter anymore. What matters is execution. The market knows this. Many investors are starting to catch up. They are not putting their heads, they're not stuck on the founders of companies owning intellectual properties anymore. It's now about execution. Thank you.